I think we're good. All right, so a couple of things are on our agenda this evening. We're going to do an overview of chapters 1 through 3. And I want to remind you, so 1 through 3 is really kind of like your American government, sort of, let's just kind of see how much you remember, right? So we're kind of breeze through that a little bit. We're going to spend hopefully the bulk of our time on our discussion of the case briefing assignments, okay? Now, because I understand that it's Monday and it's 6 p.m., and I know you're all very, very eager to talk about the Constitution, right? I'm not going to talk a lot about it. I'm going to kind of cheat and play a little video for you that I think is very helpful, all right? But you cannot go to sleep during my video, all right? It's a lovely little C-SPAN video. We're going to watch probably about 15 of it. I know, I shouldn't have said it was C-SPAN, right? Okay, so we're going to watch a few, just about 15, 20 minutes of this. And I think it gives us a nice little contextual background. You're like, oh yeah, that's right, I remember that. Oh, that article for Confederation, oh yeah, I remember that stuff, okay? All right, so let me go ahead and get this queued up. So I have it as a link in our slides. When you go home and you're anxious to go to Canvas and pull this stuff up again, I know you're going to do this as soon as you leave class tonight. You'll see that where the text is a little bit of a different color, that's where you have hyperlinks to this material, okay? So as always, I'm going to tell you that the PowerPoints are not a substitute for your reading. I want you to read the material, but then the salient points and things that I really want to highlight, that's going to be the information in the PowerPoint. So I think you'll have a better understanding if you do both. Read the material, come to class, we'll talk about it, we'll lecture about it, we'll have some discussion, do some exercises. I think that's going to really be the way to crystallize the information that you're getting, okay? Can I get somebody, Courtney, ma'am, will you do me a favor and do the lights for me? All right.
All of them?
I don't want y'all to go to sleep, so let's just do a few of them. I shouldn't set the video though. Actually, there's some very interesting people in here. Yeah, I think that's good. That's good. Make it big. Love music. Inspiring, right?
This is C-SPAN's America and the Courts. Constitution Day is this Monday, September 18th. Next, Supreme Court Chief Justice John Roberts shares his views on the Constitution and its relevance today. In one of his first interviews since becoming Chief Justice, he spoke to C-SPAN in July from his chambers.
Chief Justice Roberts, can you remember the first time you got interested in the Constitution?
Well, I'm not really sure when the first time was. I know we talked about it in grade school. You learn a little bit about the government. I don't know exactly what the class was, and I remember having a little talk and discussion about it at that time.
You remember when you got interested in it?
Well, I was interested in it in college. I studied history in college, and of course a big part of American history is the role of the Constitution and the framing of the Constitution and its preservation during the Civil War. So I came into it, I think, mostly from the angle of history, and from there into law school, where of course it was the main subject of study.
If you had to define it in 200 words or less, for a simple explanation of what our Constitution says, what would you say?
Well, these are the rules by which we govern ourselves. You know, like if you're going to play in a game, you've got to know what the rules are, and governing, of course, is not a game, it's more important. But it's the same principle. You have to know what the rules are. And governments in world history have so often abused the power they have, and people have suffered because of it. And the framers decided they were going to lay down some rules to try to keep that from happening. That's what the Constitution is.
Is there a particularly interesting part of it that you have always loved?
Well, you know, I think people tend to focus because the cases tend to be more high profile on the Bill of Rights. You know, is this under the First Amendment, the Fourth Amendment, the Eighth Amendment that prohibits cruel and unusual punishment, those sorts of things, the due process clause in the 14th Amendment. But the really interesting part of it, and I think what the framers were most interested in, is the structure of the whole thing. The decision to take the powers of the government and divide them up into 3 separate branches, and to try to make sure that each branch stayed within its own sphere. The structure, saying these are this is the presidency, this is the president's power, this is the legislature, this is what they can do. Here's the judiciary, and that's really where the main protection of our liberty resides. That is their way of preventing the government from becoming too powerful, and I think that's the part that is, at least for me anyway, very interesting.
Do you have a favorite amendment?
No, I don't think I have any particular amendment that sort of is more favorite than any other. I mean, obviously, we get a lot of interesting issues under the First Amendment and the Fourth Amendment, and the reason we get a lot of interesting issues under those, they're the ones that tend to be written for the ages, as it were, in broader terms, because I think the framers really recognized and hoped they were forming a charter to govern for the centuries. And so they were using phrases like reasonable search and seizure and phrases like that they realized would have to be given meaning by their successors.
If you were just starting out to study the Constitution, how would you go about it based on what you know now?
You know, the one thing people don't do, and by that I mean law professors, judges, law students, not just normal everyday citizens who are engaged in other occupations, nobody reads it. We talk about it a lot, we have cases about it, but actually sit down and read it doesn't happen that often, and that is a very rewarding exercise. You know, of all the major written constitutions in history, it's the shortest. It's not an elaborate code. They were laying down basic principles that they wanted to endure, and it's timeless. There are parts of it that don't seem to make much sense today, and you wonder why they're worried about quartering soldiers and things like that, but they were important then. But most of it still resonates, and you can see what they were trying to do just by sitting down and reading it.
If you had to be one of the founding fathers that were at the Constitutional Convention in 1787, which one would you have been?
Well, that's a difficult thing to. I'd like to think I would have been one of them, and there were a few that helped broker the great compromises that allowed the Constitution to become a reality. You know, when they start, we look at a lot of problems today and we think, well, this is hopeless. How are you going to solve this? That was kind of what they started with. I mean, you had small states that thought they were going to be left out. You had big states that weren't willing to give up any power. People had very different views on a lot of things. And yet they were able, by sitting down in this room and kind of thrashing it out, closing it off, no press in the room while they tried to work this out, to come up with you know, a great compromise that allowed the small states, the big states, the merchant states, the agricultural states, everybody to kind of come together. With, of course, one exception. They never worked out what to do about slavery, and just kind of shuttled that aside and decided we're not going to talk about that. And that taint in the Constitution you know, took a civil war to remove. But with that exception, I think they did a remarkable job of bringing all these diverse interests together and agreeing on a way of going forward that I'd have to say even the most optimistic of them really probably didn't envision what the United States would become.
When was the last time you read the Constitution?
Yeah, it was a few weeks ago, just in kind of commemoration of the end of the term. You know, we spent the last term issuing a lot of decisions on what the Constitution means, and I thought I ought to at least pause for an hour or so and read the original document again to see how closely I think we got to what the framers wrote.
Is there a weakness from your perspective in the Constitution?
You know, I wouldn't identify anything as a particular weakness, and to the extent weaknesses did emerge, the framers anticipated that too. I mean, the amendment process, it's extraordinarily difficult. and we tend not to focus on it. But it did allow some fundamental flaws to be addressed, like slavery. You abolished in the 13th Amendment. The Bill of Rights themselves, of course, although I tend to think of them as part of the original package, because the understanding on the part of many of the framers was that as soon as we got the Constitution in place, we would enact the Bill of Rights. But no, I wouldn't identify any particular flaw.
At what point in our history did the court solidify as a powerful part of the three branches of government? Was it right away?
It wasn't right away, and you can tell that if you tour around Washington, D.C. When they moved the government here, the first thing they did was set up the White House for the president, next the Capitol for the legislative branch. People forgot about the Supreme Court. We didn't get our own building until 1935, and I think that was a good indication of how significant people regarded the judiciary. Alexander Hamilton in the Federalist Papers said it's the weakest branch, and certainly for the early part of its history, it lived up to that. Then John Marshall came along, and John Marshall established the court as the interpreter of the Constitution. In his famous decision he wrote at Marbury versus Madison, he basically said, look, we're a court, we have to decide cases. If in deciding a case we have to determine what the Constitution means, well, that's our job under the Constitution. He regarded the Constitution as law. That's one way that our Constitution is different from a lot of others. In many countries that have constitutions, they're really just political documents. And if you have a dispute under the Constitution, it's going to be resolved however disputes are going to be resolved. Maybe in an election if you're lucky, maybe by force of arms if you're not, maybe by the mob. However political disputes are resolved, that's how they would resolve constitutional questions. John Marshall in Marbury versus Madison said this is different. The Constitution is a political document. It sets up the political structures, but it's also a law. And if it's a law, we have the courts to tell what it means, and that's binding on the other branches. And that important insight into how the Constitution works has been, I think, the secret to its success, because you do have the final interpretation of its meaning that is binding on the political branches by a branch that's separate from the political branches.
You said, first and foremost, read the Constitution. What would you do second?
Well, I'd read the Federalist Papers. These are the bits of advocacy, the briefs, the arguments in favor of ratifying the Constitution that several of the founding fathers wrote, explaining what it means. They were involved in writing it, they wanted to see it ratified, and they did their best to explain it so that the various state conventions were ratified. And again, people can get scared away by something like that. It's very easy reading. It's very straightforward. It tells you exactly what they meant when they put the executive power in the presidency and why they separated the powers in order to protect individual liberty. It's easy to read, and it helps explain what the text means.
You have a favorite one of the, 84, 85?
Well, there are a couple of them that deal in particular with the judiciary and explain why, for example, federal judges are given life tenure, why their salary can't be diminished. And what they say is the reason we do this is because they're not supposed to be responsive to the people. Unlike the legislators, unlike the president, we don't want judges to do what the people want in a particular instance. They're supposed to be following the law. And so you give them life tenure. And there was a big debate at that time. People were concerned. The judges they had experience with were the English judges, and they didn't like that experience. And they're saying, why in this new Constitution are you setting up judges for life? That sounds like an aristocracy. We're getting away from that. And so they explained, don't worry about it, because these judges are not going to be deciding important political questions. They're deciding the law, and they need to do that without regard to what popular pressures might have them do.
Does the Constitution look any different to you since you become Chief Justice?
No, I wouldn't say it looks any different. I do think, since I became a judge anyway, I have a particular sensitivity to the role of the court in interpreting the Constitution and the laws, and a particular concern to preserve the independence of the judiciary apart from the political branches, because that's what the framers recognized as key to the judiciary performing its function. And I, perhaps as part of the judicial team now, have a bit more team pride in the importance and role of the court in making the Constitution a meaningful document.
Do you ever, as you watch the debate in this country about the Constitution, you hear different people take sides, do you ever say, we really don't understand what this thing is?
I do think that judges need to do a better job educating people about their role. Too many people think whenever there's any kind of dispute in our society, well, let's take it to the Supreme Court and they'll decide. In a democratic republic, that shouldn't be someone's first reaction. Their first reaction should be to resolve political disputes in the political process. Now, obviously, one of the great insights and geniuses of the framers was to ensure that liberty was protected and that a court would be there to protect liberty. And when liberties guaranteed in the Constitution are infringed, that's what the courts are there for, to ensure that that doesn't happen. But they're not there to resolve everyday political disputes. And people's first reaction in a lot of these cases ought to be, I'm going to talk to my congressman, I'm going to talk to my senator, I'm going to call the White House, I'm going to call my governor, I'm going to talk to the people in my local government, because that's what the framers understood. That's how they understood the system would work.
Looking back, read the Constitution, read the Federalist Papers. In your own life, did you have a teacher that was particularly important to you when it comes to the Constitution, or a book?
No, I don't think there's anyone. I certainly had teachers in as far back as grade school. But there again, they tended to be history teachers, and that was what I was interested in. They inspired that kind of interest in me, and I got to the law and the Constitution through a study of American history. Books, yes. I mean, there have been great books written about the Constitution. These are things that I looked at mostly in law school, books by people like Alexander Bickel, a famous law professor who tried to explain this, what he viewed as a fundamental conundrum in our system. How can you have, in a democracy, people like me, who aren't elected by anybody, who aren't accountable to people making such important decisions? How do you reconcile that fundamental inconsistency? And he kind of struggled with that in a very, very thoughtful way that really made an impression on me.
Thank you, Mr. Chief Justice.
Thank you very much. I've enjoyed it.
All right. Interesting stuff, right?
He says way too much.
He says
Drives me nuts.
All right. So some of the general themes and principles you get out of this is the idea of the separation of powers. Did that help refresh your memory as to the separation of powers? All right. So what does that relate to then, real quick?
The three branches of government.
Three branches of government, right? And so having a very distinct bodies that operate and each respectively within their role. What else do we get out of this?
Yes. The reason why judges have tenure, I didn't know that.
That's right, yes. The idea that yes, the judges are situated in the society, but we don't want them to necessarily be influenced by the society, because we want them to be solely focused on interpreting the law without passion or prejudice, right? What else? Get a little bit of, yes ma'am.
The Federalist Papers.
Ah,
I
yes.
read about those.
Uh-huh.
That makes more sense as to what they pertain to.
Yes, all right. And what about the Bill of Rights? Bill of Rights, get a little bit of context, or why was the Bill of Rights so important, so key? What were we trying to protect? Yes, we wanted to make sure that individuals had certain types of rights were not going to be infringed upon based upon past or previous experiences. Okay? All right, so let's keep going here. Any questions about that so far? We're gonna do a quick, I want you to turn to page 3. And let's do a little overview of the Bill of Rights real quick. So, in some of this, you're gonna remember some of this like, oh, that's where that right came from. So our First Amendment, freedom of speech, religion, press, assembly, petition to government, that freedom of speech, is that absolute? Who says it's not absolute? Well, it's guaranteed by the Constitution. I can't say what I want to say.
Got you on fire.
There's
No fire.
certain things.
You remember that from last time, huh? Yes, ma'am?
There's certain things you cannot say against the government, against your president. There are certain things that you can do. Files can be charged against you.
Okay, yes, sir?
What about like defamatory comments?
He says, what about defamation? Things that you're saying that might, sort of disparage someone's name. And so we're going to talk about that and how the First Amendment is implicated when we get to our section on torts. Okay, very good. Second Amendment. Now that one, you probably just know, okay? You hear that one all the time, right? Right to bear arms, all right? Third Amendment. Right against military occupation of homes. He was talking about how some of these, you read them and it's like, what was that about? But again, it's within the historical context. Okay. Fourth Amendment. You hear about this one a lot, right? Search and seizure, right? Right to have a warrant established with probable cause. That's your criminal procedure for us, all right? So this is a general overview. Fifth Amendment. Right to grand jury, due process. Pause for a moment. If you were with me this morning, due process, or if you've been with me before, what does due process mean? Come on, due process. I told you, you had to have these two things. One without the other is completely meaningless. And I told you it's so important. It's not just in the Fifth Amendment, it's also in the 14th Amendment. Due process. Notice and an opportunity to be heard. Scratch it right down in your notes right now. Due process circle. Notice and opportunity to be heard. We're going to come back to this. All right, let's see. No taking of private property without just compensation. The right against self-incrimination, right to counsel, right against double jeopardy. These are all criminal law principles for the most part. We're in civil arena, so we're not going to be focused on these at all. Okay? Sixth Amendment. Right to speedy trial, public trial, right to counsel, right to confront witnesses, our confrontation clause. Again, criminal land, all right? Seventh Amendment, this is applicable to us. Right to trial by jury in civil cases. Okay? Everybody all right with that so far? Okay, let's keep going. Let's see. Eighth Amendment, right against cruel and unusual punishment, again, criminal law principle. Ninth Amendment, rights expressed here are not an enumeration of all the rights of citizens. So basically what this is saying is that we basically, when the Bill of Rights set forth the things that the government cannot do, but your rights are not limited just by what the government cannot do. You with me? So you have many, many more rights other than those that are expressed in the Bill of Rights. Okay? And 10th Amendment, powers not expressly given to the federal government or prohibited from the states. Who gets to do? The states. Okay? So we were saying the states can come out and play so long as it's not expressly given to the federal government or expressly prohibited from the states. Okay. So you're next introduced in the text is some ideas about theories about the law. Well, here's the thing. I'm going to tell you there are some different theories, and then I'm going to give you the bottom line, okay? So you're introduced to the idea of a naturalist theory. Should the law presume that all persons inherently know the difference between right and wrong? What do you think? No? You don't inherently know the difference between right and wrong? You don't inherently know that if you go into the store, you shouldn't pick up that candy bar and put it in your pocket?
You should. If you inherently know, then whatever it's for.
She says if you didn't hear me, know what her parents for. All right, let's go. Now, we're not going to reach a consensus, okay? We're just sort of talking about the general ideas, that we've had about theories about the law. How about this one? Should the government be deemed the superior entity that is not subject to question or challenge? No. I am the government. Do not challenge or question me. You don't like that?
No.
Why not?
Question things.
All right, so this is positive theory. All right, what about this one? Should the government adapt laws reflective of the society's current collective beliefs and needs? You say yes.
Yeah.
Why you say yes?
Well, I guess mostly for the other two also good for me, but, like you were just talking about the Constitution, like sometimes there's some things that there that don't apply, and then obviously we still use that as a basis,
Okay.
but, I mean, everything is changing in society, and we've got lots of new things now. We legalized marijuana, here we legalized, marriage, and, those are things that have adapted to society, and that's worked well.
All right.
So,
All right. Nice. I like your point.
That's
Yes.
what I was gonna bring up, same thing.
Same. Okay. All right. Well, okay. So, yeah. Anybody else? Yes, ma'am.
No, I'm just
All right.
thinking.
All right. Yes, sir.
I think it depends, because what if society suddenly wants to become like flesh-eating human people,
Flesh-eating human people.
I didn't think that. Like, they want to start eating people and killing people just for the heck of it. Should the
Okay.
laws suddenly change because of that? Like, yeah, it's totally fine,
Okay.
since y'all want it.
All right. Okay. Let's look at some different. What about this one? Should the goal of the judiciary be to strike a balance that allows for maximum personal freedom without detracting from the general public's welfare? So kind of like the judiciary in a balancing role. Personal freedom, public welfare, to the extent possible, kind of keep them in the equilibrium. What do you think about that? All right.
Yeah, but I mean, I don't know. You have, like, if there was some, like the Ebola breakout or something, and someone's walking around transmitting, I mean, giving, I don't know, you've got to quarantine them and then their rights are taken away from them, but it's to save the rest of the public, type of thing.
What else? Yes, sir.
I'm kind of confused. Are these like theories, or is this like, it sounds like what our laws are based on?
Ah!
This is like the American dream. It's like the individual in society just is America.
So I think you raise an interesting point, and I think that is that none of these are mutually exclusive. I think as you look throughout history and the progression of our law, you can probably make an argument, I see some change here. This looks like maybe the judiciary was trying to strike a balance with this issue. Maybe the judiciary was trying to actually respond to the change in society and social norms, right? So it might not just be that one theory fits every, a part or every piece or change in the law. Okay? All right. So ultimately, irrespective of what theory you choose or pick, bottom line, law and morale are not the same. Okay? Whether you think people should inherently know something or whether you think the law should be respond to moving in social times, we have to just sort of have a consensus that law might not necessarily always be consistent with what you believe to be morale or moral. You okay with that? All right. So some foundational terms. So the first term here is the idea of a right. Okay? So I'm going to read it and I'm going to explain it to you. Capacity of a person with the aid of the law to require another person or persons to perform or refrain from performing a certain act. So, what's a right that you have vis-a-vis me right now? What's a right that you have?
To object.
Yes. We talked about objectives. Okay. All right. Give us another example.
I don't know, I have the right to bear arms.
Okay.
Is that what we're talking
Okay. But what's a right that you have vis-a-vis me right now in this class, perhaps?
Right to leave.
The right to leave? No, you
I mean,
can't.
like, rights of
What's a right to leave?
Right to learn.
You have the right to learn. Okay. The right to express an opinion, right?
The right to be treated fairly.
The right to be treated fairly, right? Do you have the right for me not to hit you right now? Is that a right? That's aided by the law?
Yeah.
That refrains me from doing something, right? Okay, so that is a right that you have, okay? The duty, on the other hand, this is all reciprocal. So you have that right not for me to hit you, and I have a duty not to hit you. Well, he talked about him eating people. I mean, I could talk about it. Are we okay with those two concepts? All right. So we're just laying some foundational terms because this is stuff we're going to come back to as we move through the rest of the material, okay? All right. Public law. So we're talking about rights and duties. So we're going to have some rights and duties under public law. We're going to have some rights and duties under private law. And right now we just want to draw the distinction. So public law is basically government's rights and powers and its relationship to individuals. So public law, we're talking about the government and the society, individuals. Is that okay? Mm-hmm. So criminal law. So remember how we said last week, if you're charged in a criminal case, who's the plaintiff?
The state.
That's right. We use the term state very generically, right? So it could be the city, it could be the state, it could be the federal government, right? And then who is the victim?
Society.
Society, the public. You have wronged the entire community, right? Okay. Private law. So private law is vis-a-vis citizens, okay? So for example, let's see. If So we're involved in a car accident, John. Can it be your fault?
Sure.
It was my fault last class, wasn't it? Okay, so John, the accident is John's fault, okay? At least we think initially, okay? But then when the medics respond, I had a rough day, it's a long class, so before I got on the road, where, is there a bar around here?
I'm sure.
Okay, so I found some kind of bar, and I had a few drinks, okay? I just had a little, but I don't think I was really toasted though, okay? I mean, but I was speeding a little bit, so I get stopped after, we have our little accident, okay? So you're like, you look like you've been drinking. I was gonna just, exchange information, but I'm gonna call the police, right? Because you would do this, right?
Mm-hmm.
Because he's a concerned citizen. Okay, all right. So, public law issue? Public law issue?
Yes.
Yes, because I potentially committed a crime. And the crime is committed not just against him, but to the entire public, because there are other individuals who also could have been put at risk. Okay?
Are you saying it makes it public because of your drinking?
Hmm?
It makes it public
Because it's a crime.
Because of the drinking.
Because it's a crime.
Yeah.
He's drinking, yes, exactly.
Okay.
But now, in addition to it being a public thing, right?
It's also private.
That's
Yeah.
right. Because now he might have a private cause of action against me for what? We'll talk about it. What? Negligence. That's right. Is that okay? But you see how in that action, under private law, it's just him. Okay? Because it's his car that was damaged. It's his medical bills, right? That doesn't implicate everyone else, right? You weren't a part of it. You weren't there. You can't join his lawsuit against me. Okay? All right. Let's keep going. So civil law related to private law. And that's what we're going to be talking about in this class, civil law, okay? So torts, negligence, everything that's outside of the criminal arena, okay? Party bringing the action, we spoke about this last time, is the plaintiff. And the typical burden of proof in our civil cases is going to be preponderance of the evidence, which means what? Do you remember? Oh, you guys, look what I have. Oh, yeah. Yeah. All right. Let's see. Can I get a drawer? Can you help me out, Jennifer? Come on. We have history.
I couldn't tell you were looking at it.
All right. And look, I got all different kind of colors for you. Oh, I got red and blue. Okay, so we need, remember this spectrum of burden proof? A little bit? A little bit. It's okay. All right, so let's draw a line here. Let's draw a straight, yep, across the board here.
Oh, I remember this.
Yeah, I knew you remember. That's why I called on you.
Well, I'm gonna be able to fill it all in, but.
All right. All right, so the very front, what are we gonna put? Let's draw a line and put 0.
Here?
Yes, ma'am. All right, and at the end, let's put 100. All right, John, we just said that our standard burden of proof, you know what, that's okay. I already picked on you. Let's play this game. If I remember your name, then I get to call it. How about that? Nicole, sorry. All right, so let's see. We just said that the typical burden of proof in our civil cases is preponderance of the evidence. Do you know what that means? What's the other phrase? Yes, sir? Somewhat. I like it. Close. Can you help me out, Dylan?
Well, I mean, mine is, I don't really know the exact definition, but I kind of understand it as the burden of proof in a civil case.
Yes, you're right. You're
I
right.
mean, I don't-
And we're just trying to flush it out a little bit more. If we were to give it a numerical value, what would it be?
Have to outweigh.
51.
50.
All right. 51. All right. 51. So will you put a 50 in the middle there?
Mm-hmm. Up there.
Yeah. That's good. And then, Courtney, will you turn the lights back on so we have a little bit of light? We're doing this in the dark. Okay, so then above, so put 51 next. And then write preponderance of the evidence.
Right underneath?
Yeah, so you're good. Anybody remember the phrase that we're going to, so if it's 51%, it means, what's the other language? More
likely than not.
That's right. More likely than not. So we're going to put that under that preponderance of the evidence. So more likely than not. Are we okay with that? All right. And then what's our next burden of proof? You want to? Are you okay with continuing? Okay. What's the next level that we had? No, not yet. Not yet. We got something in the middle.
Clear, cogent.
Clear, cogent, and convincing. And where is that going to go? Anybody over here? Where's that clear, cogent, and convincing standard going to go? I know you're like, I know this. You want to go?
Just
Yeah,
almost at the end,
that's right.
99 or-
Yeah, so just put it right in the middle. So we know it's above 50. Yep, that's about right. So I want you to notice that the only thing that we're giving a numerical value to is the preponderance of the evidence standard. All right? So nowhere else are we going to see any sort of number equated with the burden. And the way that we explain it is just that it's a higher showing than the preponderance of the evidence. It has to be clear, cogent, and convincing. But it's not as high a standard as beyond a reasonable doubt. So, ma'am, will you put that up there? And are we going to put beyond a reasonable doubt at 100%?
No.
Nope. Yep, that's perfect. All right, we're going to fill in one more thing here, then I think we're ready to move on. What sort of cases are going to have to meet the clear, cogent, and convincing standard? What sort of civil cases? I gave you a few last week. But it was the first day of class, so, y'all remember, that's all right. Child custody. Oh, very good. Dependency cases. So dependency, clear, cogent, and convincing. Oh, yeah, it doesn't matter. We just want to indicate that dependency cases are where we're going to have this standard. What's a dependency case? Anybody remember?
Where the child's getting taken away.
That's right. The state, for some reason, is coming in and saying, like, ma'am, you are incapable of taking care of your children. Your parental rights need to be temporarily interrupted or perhaps permanently terminated. That's the standard. Okay? What's another example of a case where the standard is going to be clear, cogent, and convincing? And we mentioned it earlier. We talked about it earlier in terms of, where did we mention that? Talk about my name.
Defamation.
That's right, defamation. All right, what else? So defamation. All right, let me give it to you. Civil fraud. We talk about fraud. We're going to have to meet this higher burden of clear, cogent, and convincing. We want to contest the will. We're going to have to meet that burden of clear, cogent, and convincing. All right, good job. Thank you. Any questions about this? All right. So next week, when we start to transition into talking about different types of torts and talking about the elements that we have to meet, we're going to start talking about the burden of proof, meaning the evidentiary standard by which we have to prove that. Okay? All right. So criminal law, we did the little chart last week about the difference between civil law and criminal law. I think we're okay, right? Yes, yes? Substantive law. Procedural law, we spoke a little bit about this, but just to remind you, so substantive law is what are my rights, right? Or what do I have to prove? So for example, if we were talking about negligence, we look at the statute, and the statute says that in order to prove negligence, we have to show, anybody? That's all right, we're gonna learn about it in class. Duty, breach of duty, proximate cause, blah, blah, blah. So that's what our rights are. What do we have to prove? Procedural law, on the other hand, is what? How do we interpret this? What's procedural law, Brian?
Like the
Yeah, you got it.
I mean,
yeah, go with it.
the RCWs, like like exactly what you violated, or the process, the court process.
The court process.
That's what it is. Like
all right.
what's gonna happen
So
in court.
procedural law is how do I go about enforcing my right? What court do I file in? Who do I file against? How do I serve them? What's the time frame they have to respond? We okay with that idea? Did I lose anyone? No? Yes? Let me phrase it how you know. Do I have any objections? No. All right. All right. So some other terms that we're going to use to describe our system. Adversarial system. Does that mean we got to go in court and beat each other up? Literally? No. It just means that the way that we describe our system here in the U.S. is that the parties themselves initiate the litigation. Okay? So if we're in a criminal arena, we have some sort of state entity initiating the proceedings. They file a case in court, so forth, right? Parties respond. In the private arena, we have a private plaintiff who's going to file their case, right? Whether it's with a lawyer or what they do without a lawyer, so forth. For the parties, okay? And we'll juxtapose that to, I'm gonna come back to the common law system, okay? We're gonna juxtapose an adversarial system to a civil law system, all right? Where we have basically an inquisitorial system by which the judiciary, that judicial body, is going to initiate everything, conduct an investigation, do the proceedings, and so forth. We have examples of that here. We're not going to focus a lot on here. We're just sort of laying some terms so you understand, okay, this is the kind of system we have. There are other types of the system that are a little bit different. And here's how they work. Everybody okay with that so far? All right. Let's come back to that idea of common law. Okay, that was interesting.
This is C-SPAN's America and the Courts.
But it did kind of fit with the idea of talking about common law, right? It was like right on cue, right?
Like, that's good.
All right. Same rule. TCC and the alcohol stuff, right? Let's see. We have a racer. Are we okay with this? You guys got this done? All right, I'm gonna erase. Okay, thank you. Well, you know, they say you're supposed to incorporate into like your daily stuff. It does too, Kelly. All right, I'm putting that down on my arm lifts. There we go. All right, so our provision is going to be, let's see, you guys remember this. TCC prohibits okay. Consumption of alcohol. Alright, so here's our provision. Okay? TCC prohibits consumption of alcoholic beverages on campus. Alright? Everybody okay with this? Do you agree with this? Don't answer that. Plead the fifth. Okay. So let's start out with yeah. All right. So Bree, oh, you're fine. Oh, let's use Courtney, because Courtney's really up. Let's use Courtney. Courtney's okay. All right. So Courtney hasn't been feeling too well today, okay? Right? She had, you know, I did not say she started drinking.
No, she brought a drink now.
Oh, interesting. Oh, yeah. Okay. So she hasn't been feeling too well today, okay? But nonetheless, she's very dedicated. She wanted to make sure she came to class, all right? She's having a fever, you know, she's got a little shakes and whatever, right? So what's the medicine she can take for, but it has a little alcohol in it? NyQuil, all right? So I walk by and I see she's swigging from the NyQuil bottle, okay? And I am like, oh my goodness, this is in violation of our policy, all right? So we're gonna set things in motion and she's gonna be disciplined, maybe put on probation, whatever, right? What's she gonna do?
Object.
That's right. She's gonna follow suit, right? She's gonna somehow appeal, right? Are we okay with that idea? All right. So it's gonna be Courtney. Which last name, Courtney? B
L-E-I.
L-E-I
P-H.
P-H
A-R-T.
A-R. F? No,
It's P-H. I was gonna say not New York.
Okay. Versus TCC. We okay? Everybody right with this? Okay. So now the court has not had to address an interpretation of this provision before. All right? So what are we going to call this? If you did the reading, or even if you flip through the PowerPoint slides. Not yet. That's what we're talking about.
First impression.
Yes, right. So this is going to be what we call a case of first impression. Everybody okay with that concept? All right, because the court has not before had to decide this particular issue. Okay, case of first impression. So now, what are they going to do then? What's the court going to do? It has this case, and it's trying to interpret this particular provision. What's it going to look to?
Existing.
What?
Existing.
Well, no.
Well, we'll see if there's some other cases that might be enough.
From another school. Maybe cases from another school.
Cases from another school, another court. All right, and then that's going to beg the question whether or not that's relevant or whether or not it's actually has any sort of authority or if it's binding for us right here. What about if it looked back to the history of the case itself, of the law itself? Maybe if we went back to the record about, okay, when this provision was contemplated, what were the discussions? What's the record say about what our intent was and what we were trying to do? Might that be one way? All right, so what do you think the record's going to say? Probably they probably weren't thinking about NyQuil, don't you think? Right? Okay. So the court's analysis is going to talk about how NyQuil probably was not this provision as applied is probably inconsistent with the way in which it was contemplated this law would be whatever, right? Okay, so we're going to get a ruling. You think she's going to win? Yes. She's probably going to win, okay? So we're gonna take this, which is a different color. Alright. She wins, right? And this is gonna go on a shelf someplace. Are we okay with that?
Would it change the rule, like, and add it into it?
It wouldn't necessarily change, but now, so we said it was a case of first impression, right? Now, what do we have?
Case of precedent.
We have some precedent. And that's another term that's in your PowerPoint slide. Have I lost anyone? Does this make sense? So now we have some precedent in terms of how this provision is being interpreted and applied. All right? Next case. Ma'am, what's your name?
Trish.
Trish, you okay? Can I play with you? Mm-hmm. All right, so Trish is very, very into making sure she has fresh breath. All right? And so she keeps a bottle of Listerine ready on hand. And Listerine has what in it? Alcohol. So she takes a swig in my class. I'm like, oh my God, you violated the policy, right? Because I'm just a fanatic, lunatic, right? So same process, right? So now the court has precedent, right? And now we're gonna do what? So if you are, tell me again, Andrew? All right. So Andrew, you represent Trish. What's your argument to the court, drawn upon what we just talked about with this previous case?
I would say that we should go with the same case and say she.
Okay. And what else? Flush it out for us. You want to pass? Hey, did I tell you guys that you can pass? And I don't draw any negative inference from that by calling you? All right, good job, good job. You saw me coming towards you. What about you? No? You want? So what's the argument?
I'd probably argue that there's probably the same amount of alcohol in Listerine that there is in NyQuil. Kind of like the amount, if not considerably more.
Yes. So what you're going to do is you're going to analogize to this previous precedent now. Your Honor, this case is very much similar to the Lepart versus TCC. In that case, the issue before the court was whether or not NyQuil constituted an alcoholic beverage. In that case, the court decided, no, it did not. Likewise, in this case, we have Listerine. We would argue Listerine is like NyQuil. It's not an alcoholic beverage. We okay with that? So, Trish wins her case, right? Now we have, Trish, give me your last name.
Wyatt.
Did I make that up? Is that right?
That's right.
Okay, cool. Versus TCC. What's it going to do with that? Box it up and put it on the shelf. What are we doing here? What are we constructing? We're constructing common law. And that's what common law is. It's judge-made law. Right? So the court gets a case, and they use previous cases, and they analogize or distinguish, and they use that to make a determination. You okay with that? So that by the time we get to my case with a bottle of vodka, I'm done. Right? All right? That's a plea case, right? Okay. So, anybody okay? Everybody all right? All right, let's keep going. Without our soundtrack. We talked about that.
So can I just ask a question?
Absolutely.
Sort of pushing on this. So if you argue that Listerine is like NyQuil because it has the same amount of alcohol, what if somebody brings, tea, but puts a little shot of something in there and says it's the same amount of alcohol as it is in Listerine? Is that still fair game?
What do you think?
No, because that's consuming an alcoholic beverage.
That's a
Yeah.
beverage.
That's
Not medicine.
But that's a beverage.
It has to do with intention.
Listerine
Yeah.
and
And
NyQuil
so
are
what-
both
yeah.
That's
medicinal.
what I would say.
And so but what you're saying though, and then what the response is, this is exactly what's going to happen. So your attorney representing you for bringing your alcoholic tea. This is like these other cases, and it's not really a beverage, right? You representing TCC, you're
Like a tea, it's a herbal tea.
you get a license for that. But here's the thing, ladies, you get to argue all of that, right? And then likewise, TCC is going to say, this is like whatever, right? And so what are we going to do? We're probably going to bring in some experts. We might have some testimony about all that kind of stuff. We're going to brief the issue, and then who's going to decide? The judge. And then if you don't like his decision, because I'm telling you right now, you're going to go down because of the alcoholic beverage, what do you get to do?
Appeal.
You get to appeal. Are we all right? Yes, sir.
At what point in like the case law timeline do we decide that it's time to update the statute?
Oh, that's very interesting. I think my classic answer?
It depends.
It depends. It depends. Is the statute antiquated? Has have things changed so much that now we need to go back and reconsider this? So it just kind of depends.
What's antiquated mean?
I mean, it's still so old. I mean, in terms of, we've progressed so far beyond the time at which it was originally put into place. All right, let's see. The next concept you're introduced to, let me put the screen back on. Stare decisis. Let the decision stand. So what this means is, so say now we've just started to develop some case law. We've just started to take a position, all right, on these cases. So we can pretty much have an educated, intelligent guess as to how the court might rule based upon looking at these other cases, right? So all stare decisis says is that where the court has already decided this issue, absent there being some reason to do otherwise, we're going to stand by the decision. Okay? Now it doesn't mean, though, that the court cannot correct a previous erroneous decision, or erroneous when it's bad decision. All right? What's your classic example of that? Let me put it like this. You wouldn't be here, I wouldn't be here, you wouldn't be here, you wouldn't be here, you wouldn't be here. What's your classic example? Brown versus Board of Education. Right? Right? Because if the court said, well, wait a minute, stare decisis, we let it stand, we never ever change, we just stand, we're not changing, right? Well, no. That's your classic example of how the court can go back and correct its path. It can correct the way that it's going. Okay? All right. Yes?
But when they reviewed Brown versus Board of Education, like, wasn't there like, don't you need like a really concrete reason to go back and change something? Like, cause like I think I read once that because like they based the original decision on like making separation of schools legal because like there's a scientist that like proved that like the African American brain and white brain were different, but then obviously science caught up and said no, that's not true, and that's why they were able to go back.
Well, I think that, first of all, I think that, so while that may have played, I think that's a less part of Brown versus Board of Education. When you read the cases, it was talking about the psychological and emotional effect and whether or not it actually did constitute separate but equal. But nonetheless, I think ultimately, because Brown versus Board of Education is a big, long case we could spend the rest of the class talking about, the only point that I want to make with it is the idea that while we generally have this concept of stare decisis, which means we look to previous things and we stand by them, it does not mean that the court won't say, well, wait a minute, we can still change course and we can decide something different if we need to. And there might be a myriad of different factors that come into play in terms of why the court says it's appropriate at this point in time, at this point in history, to change our course. So you have the example of Brown versus Board of Education. You have the example of same-sex marriage. For years and years and years, the court said no, no, no. And now we see a change. So again, the factors, the political climate, the arguments in the case, the evidence, all of that is going to play a significant role in terms of why the court says maybe it's time to do something different. Is that okay?
Yeah.
All right. Yes, sir.
So let's say you have a case of first impression and 20 years go by and it changes, but there's been like hundreds of cases that have been stare decisis upon that original one. It changes, and then this flood of people appealing now that it's changed. You know what I'm saying? Like they've changed that now. What happens with all those judgments that have happened? Is there a statute of limitations or?
Well, let's see. It's going to depend. I can think of, let me give you this example. So under the statute for sexually violent predators, there used to be, so sexually violent predators are individuals who the state has come in and said that we believe that unless this person is confined for purposes of treatment, right, they are going to engage in sexually violent behavior. With me? So the statute had provided that once a person is confined, they actually had to make some sort of demonstration that their condition had so changed such that it would be safe for them to be released. Everybody okay with that so far? All right. So then people would start, not people, certain individuals, we got a lot of cases where they say, hey, I've changed. I've been gardening. I've been reading, I'm not kidding you. I've been participating in recreational activities. So this is a demonstration that I'm changed and I'm ready to go out and participate in the community, right? So we have this case that comes down and says, because they appeal, because we're saying no, it doesn't, the court's agreeing with us, and ultimately it goes all the way to the Supreme Court, and the court says, you cannot dictate the manner by which people say they have changed. So if this person says, hey, I've changed, and they get an expert that actually provides testimony to that effect, then hey, the way their statute is written right now, it is what it is. So do you know what happened after that decision came out? The floodgate opened and everybody at the special commitment center said, hey, I changed, right? And so the question goes back to, in terms of the time frame, it depends upon what the statute says. So the statute might say that this time frame is only be applicable for XYZ or so forth, or it'll be retroactive or whatever. Let me just say that that statute was immediately corrected, so the floodgate shut. But that's just an example of how you can have that sort of issue. Everybody okay with that example? All right, let's keep going. So I'm mindful of the time. We started a little bit late. I think I have, if you'll let me get through, I think these next two slides, and we can take a break at 7:15. You okay with that? Mm-hmm. All right. So, other foundational terms. This idea of equity. So the only thing that I'm going to talk about this slide in relationship to the next slide. The only thing I want you to understand and appreciate about a court of equity is that when you're in a court of equity, what you're saying is that when you sue someone civilly, what are you getting? What are you seeking most of the time? That's right. You want money, right? But if you're coming to a court of equity, your primary contention, the reason why you're in a court of equity is because you're saying that money is not an adequate remedy. It's not enough. You actually need to have the court make the person do something. That's right. So specific performance. Make them comply with the contract. Make them do what they failed to do. Okay?
Like a tree, like my neighbor's tree growing into my yard.
That's right. Make them cut that damn tree down. Okay? Injunction. You take my Mimi, right? Injunction. Make them stop doing something. Reformation. I need you to fix the contract. You follow me? See how these are not things that we can sort of solve with money? Rescission. Allows the party to invalidate the contract under certain circumstances. I don't want the money. I just want the contract to be undone. All right. Now we can break. About 5 minutes. You in 10 minutes? Let's do 5 and then we try to get out sooner. All right, let's do that. All right. Okay. Oh, you said you didn't like none of this color. I go clear, but I'm gonna try it though.
Try some color.
Try some color. I can be bold. Try some color.
All right. I'm good over here. Trying to just gauge our time frame, guys. Okay. Right, good job.
My girlfriend who's in the accounting role, which I think is really conservative, told me I should cut my nails. And I can still type and do everything you think I should.
I think
I don't think it's, I don't think at all that way about the question, but I think that you're the best gauge of that. If you think you can do faster with that,
Yeah.
then
I'm fine. She thought that it could flash maybe and like more
I don't
conservative.
know, but sometimes you just go by the culture of the opposite.
Okay.
That's
Okay.
what
He seems pretty laid back, so.
Okay.
Yeah.
And here's the thing, you got to return to tell everybody.
That's
that
true.
they're good
That's
markets,
true.
you know what I mean?
Okay.
So,
Yeah. All right.
But good job.
Thank you.
Okay, so I think we can do this in like 2 minutes. And then we can switch the paper. You all right?
We just haven't. Once we start, because I'm not in any, hurry.
So here's the history of
Just go to the next corner.
I'm just gonna
But-
read it all. So Washington
Yeah.
State did an access to the legal system, access to justice survey. And basically, what they discovered is that nobody is more knowledgeable. Not just poor people, even middle class and so on, right? And so the idea was, how can we, what is it? Limited legal license technician. Oh, okay. And so what they came up with, well, the Supreme Court said, find this away. The Supreme Court made this law that said, hey, we're gonna allow people to, if they meet certain requirements, to practice on a limited basis. Not litigation, so there are lots of restrictions, but even though they're kind of looking at expanding. But for right now, we take, we have 2 more things. And APA includes the American Bar Association approved paralegal training program, where TCC it is. Exactly. Then we need to complete the core requirements. Right now, it's only family law. And those classes are after we done. You also have to do 8,000 hours of subsequent legal supervising and teaching. That's great. You know, this is great because you have it, you can use that part of your record. So all this you've already been doing in the field as a paralegal, as an intern, as a volunteer, all of that is accounts for your 8,000 hours. Like you have to ask, okay? You also have to take an exam. It does not have to be no volunteer work counts.
What you said when
So it's a total of, I think it's 45, it's 15, it's 555, it's 15. It's 15 online. So you can do it online. It used to be, here, you had to go, and I like that idea because, you know, but right now it's only family law. They're looking into expanding what the additional areas of practice might be. It's on the table. I highly doubt we're gonna go immigration. So like right now, what we're doing is asking people for their ideas and suggestions about what the next, area should be. I'm voting against immigration laws. I am. Only because unless they're able to very carefully define a limited scope, I just think it's too much, it's too complicated, it's too vast. Immigration law implicates family law, criminal issues, it's huge. Bankruptcy. Good one. Yeah, I think bankruptcy would be okay. I think bankruptcy would be good. On the paralegal site, which I'm just gonna update in terms of making sure everybody has access, there's a nice little link to all the LLT information, and I think also there's gonna be a presentation that's coming soon, October 15th, I wanna say.
Okay.
But I'll send that a reminder, okay?
Cool. Yeah, thank you.
Yes, sir.
Yeah, we were wondering, why is contract
I wish I had been telling you.
Yeah, that law sounds like everything.
That's just how my professor did it in law school. I'm sure she probably had a reason, I never cared to ask, she was really great and all, but she was talking about so much stuff, I was like, okay, K, contract.
I don't know. There might be some. Yeah, I mean,
You know.
I'm just passing on the love.
Yeah, so this just sounds
Setting
like
precedent.
from this time what they did.
All right.
Everything. Signature, okay.
Yeah, you just fill it
Yeah. Delete that, use that one, yeah.
You guys ready to get started? I think it's been about 5 minutes, has it? Yes, yes? Let's do it. All right. A perfect timing. We're just getting ready to get back started. All right. So let's see. Sources of law. We have many different sources of law. You heard we started off with talking about our Constitution, so that is one source of law. We have our U.S. Constitution, which is the supreme law of the land. And in addition to our U.S. Supreme Constitution, we also have our state constitution. Okay? I'm not saying, no, I still do this. Yeah, the way that I like to describe your constitution, what do I call it? Anybody remember?
Something about love.
That's right. It's your love letter. Have you gotten a love letter before? No? If you haven't, I don't want you to worry. You have two. You got one from the federal government and you got one from the state government. Okay? And in that letter, it tells you all the things it's not going to do. Right? Remember? I'm not going to take away your freedom of speech. I'm not going to take away your desire or your ability to peacefully assemble. I am not going to take away your right to bear arms. I am not going to do an unreasonable or unwarrantable search and seizure. I promise. With me? Right? Okay. And then the state sends you a letter too. And the state, they make you some promises too as the things they're not going to do to you. And if you compare at least the letter that you get from Washington State with the letter that you get from the federal government, guess who loves you more? Washington loves you more. Why do I say that? Washington gives you more rights. Classic example, let me tell you. I don't think you can get a better example in terms of demonstrating how much more Washington loves you than your garbage. You're garbage. You heard me, you're garbage. Let me tell you why. Is he recycled? This is my house. Okay, this is my curb. I came out, I set my garbage out on the curb. You with me? Okay? Federal law, guess what? No right to privacy. Gone. I can dig through this. Find all your stuff. You with me? Right to privacy, you with me? Federal law. Okay? Everybody okay with that? All right. Washington law? Washington loves you more. They give you more rights. This is my curb. Garbage man, you come. Privacy right still? Yes. Down the street. Collect more garbage. Privacy right still? Yes. There's more garbage. Privacy right still? Yes. Into the block. Commingle. Lots of garbage on the top. Privacy right now? No. You with me? Washington loves you more. You get greater rights, greater protection. Washington says that you have a right to privacy in your garbage. Even after you dump it, put it on the curb, it goes to your neighbor, then your other neighbor, right? You don't lose that privacy right until it gets somewhere down the block and it's commingled with other garbage. Make sense? Washington loves you more. Now, it can love you more, but it can never, ever love you less. All right? So the state constitution can always give you more rights, but it can never give you less. We okay with that? All right. Other sources of law. Treaties, compacts, federal statutes. These are just some general overview.
I don't know what interstate compacts are.
You know, what's an interstate compact? This is an example of an interstate contract.
An agreement,
What
like
if-
oil?
Yeah, like what does it sound like? It's just an agreement between states.
Okay.
Yeah, agreement across, exactly. And these are just examples of other sources of law. We're not going to talk a lot about these, but just in terms of foundational stuff, just so you have an idea of what would be examples of other sources of federal law and state law. Okay. Do you guys remember doing research projects? And you had to talk about your primary sources of law and your secondary sources of law. Remember this? All right. So our primary sources of law would be what? What do we mean when we say primary? Huh? Direct, firsthand. An example would be the Constitution, the federal Constitution, or the state Constitution. What else would be an example?
RCWs.
RCWs, statutes, okay? The treaties, okay? Huh? Stare decisis. Yes, so that would be in case law. Yes, so yes. Okay. All right, let's see. Restatements. So these are, this is another example of a source of law, but restatements are what we're going to call secondary sources. So, remember our little thing that we did on the board over there? We were doing all the examples of the case about the TCC, whatever, right? Can you imagine there are lots of different cases under lots of different areas of the law? Right? There's a whole bunch of stuff. So, a group of nerds, some lawyers and judges and other people who were just fascinated with the law said, hey, we should organize this. And we should come up with a summary. And we should categorize all the negligence cases over here and all the contracts cases over here. You with me? So that's your restatement of laws. It's not primary, it's secondary. But it's very helpful in terms of being able to understand, okay, what's the sort of historical path? What are the cases that are relevant to this particular area of law? We okay with that? All right. Legislative, very direct and simple there. Treaties, we talked about that. Administrative law. So for about just about everything you do in life, there is some sort of administrative body that has something to do or say with what you do. All right? So these are examples. Public health, Department of Health, administrative, public safety, military forces, police, all of these are examples of some administrative bodies, okay? We won't deal a lot with administrative law in the class though, okay? But you should just know it's another source of law. We talked about legislation in general. There's federal and state.
When you're pursuing a case, does it matter whether you're sourcing primary or secondary?
Oh, that's a great question. And yes, it does. And we're going to talk about it in just a moment. Matter what case is primary and secondary. Oh, and we're also going to talk about published, non-published along those lines, okay? Just writing this up here so I don't forget. Okay. All right. These last couple of slides relate to talking to you about the bicameral system of our government, House of Representatives, senators, what the time frame has to be in terms of how long they're elected, how old they have to be. I'm not going to quiz you on that. I want you to read it, just so you kind of have some background, foundation stuff. But in terms of what you're going to be quizzed on, you're not going to be quizzed on that, okay? Remedial statutes, you heard Justice Roberts talk about the example of the 13th Amendment in there. Again, a remedial statute is something that the court does, or a change is made to correct the law. Okay. Same with the legislative process. I'm not going to go through this in any detail. Okay. Law is introduced to the legislature as a bill. It first comes to the House of Representatives. Once it's proposed, it gets a number. Sometimes you'll hear it referenced by the individual or the cause. Can you guys think of an example? The Becca bill, right? What else? Brady. Anybody else? So once it's introduced, it's assigned to an appropriate committee. You got hearings on it. You pass it back and forth, right? This is all very fascinating stuff. No? You don't think so? Okay, fine. Good thing the class is not focused on this. All right. but you have a quick little overview of that information. Okay. Let's see. That's it. In fact, I think next time I'm going to take that out. It's not that essential to what we're going to cover in class. Sometimes it's helpful. People like to have that information. Your exercise that you'll do, applying the concepts number 1, it does actually have you go and look at our legislative, the website and sort of pull the bill. I think that's something that that you'll get something out of, at least to sort of see how, the history of it and see what the comments are and things like that. But beyond that, that's the extent to which we'll talk about that. Okay? I really want to transition now and talk about case briefings. So roll up your sleeves. You ready? Yeah? All right, let's do it. Let's see. So what I'm going to give you now are 2 different documents. I'm just going to have you pass these around. So one is the case that we're going to practice our case briefing with, and the other is a case briefing grade sheet, okay? All right. And for this, I'm going to write on the board. And pull this up. All right, so remember last week when we talked about the critical thinking model? Technical difficulties, hold on one minute. All right. So remember we talked about the critical thinking model, right? So we're gonna try to weave in some of those principles as we go through and talk about the case briefing, okay? So there are a couple of different components, and I want to start by saying please follow the guidelines. Please follow the titles here, okay? So you'll see when you look at the sheet of paper, there are different components to the analysis. Go in order of the analysis as I've given it to you. So if it says you start with the material facts, please start with the material facts. No, seriously, okay? All right, so material facts. Material facts. So last time when we talked about the critical thinking model, we talked about being objective, right? We spoke about being clear, trying to be accurate, trying to be unbiased, okay? I want you to flip to page 3. Page 3, the right-hand side, and see where it says facts? Yeah. Let's start there. We're going to read a little bit of this out loud. Can I get a volunteer reader, please? Yes, ma'am. Thank you. Go ahead.
In December 2004, Ms. Rockwell had been employed by 9 Mile Falls School District as a custodian for approximately 8 years. On December 10th, Ms. Rockwell was scheduled to work the second shift from 11:30 a.m. until 8 p.m. at Lakeside High School. She split her shift that day with a coworker and was scheduled to be at work at 4 p.m. Right. Around 1:30 p.m., Ms. Rockwell received a phone call from the chief building custodian for the high school. He stated that Ms. Rockwell's coworker was distraught and needed to go home. Ms. Rockwell was going to report to work, but was not told why. She later learned that a student had committed suicide in the main entrance of the high school by shooting himself in the head.
Okay, pause right there. So what happened? What's happening so far?
Suicide.
Good. A suicide? Okay. What else?
She worked in a foundation.
She worked there. What's her position? Okay, so we have a custodian who's been asked to report to work where a student has just committed suicide. With me? Are we okay?
Right.
We read a whole bunch, but you see how we just synthesized that information? All right, let's keep going. Can I get another reader?
Sure.
Yes, ma'am. Thank you.
Paragraph 4.
Yes, ma'am.
When Ms. Rockwell arrived at the school, she was initially placed on duty at the front gate of the high school to prevent the media and unauthorized individuals from entering the school grounds. She remained at that location until approximately 3:30 p.m., at which time the school vice principal asked her to go inside the building.
Please, thank you.
After Ms. Rothwell arrived inside the school building, Superintendent Michael Green ordered her to clean up the scene of the suicide.
Pause right there. Say it again. Read it again. What was she asked to do?
Clean up the scene of the suicide.
And what's her role?
Custodian.
Custodian. Okay, keep going.
Superintendent Green repeated the order 3 times. Based on Superintendent Green's orders, Ms. Rothwell walked to the school entryway where the 777 shooting had taken place. 2 deputies and a detective were present. Ms. Rothwell overheard the detective say the name of the suicide victim. After learning that the victim was a student whom she knew personally, Ms. Rothwell became very distraught and upset. She then went to her car and left the school grounds for approximately 30 minutes to compose herself.
Okay, so now what else do we learn?
She knew the student.
She knew the student. Let's keep going. Do I have another volunteer reader? Anybody? Yes, ma'am. Thank you.
When she returned, one of the deputies told Ms. Rothwell that she was not allowed to touch anything at the scene. Bob Anniker, the Lakeside High School principal, then ordered Ms. Rothwell to go through the classrooms where the suicide victim had attended class earlier that day to determine whether, 350, he had left any bombs. Ms. Rothwell...
Pause right there. So the numbers, just so you're okay, that's just a reference in terms of if we're trying to cite to the record or whatever, right? Like a placeholder. But say again what you just read.
So Ms. Rothwell to go to the classroom where the suicide victim had attended class earlier that day to determine whether he had left any bombs.
Excuse me. Who? No, and let's go back. So who is she again?
Custodian.
I'm going to keep emphasizing this, right? So she's a custodian. She's reporting to work, and she's been required to clean up the suicide. And now she's been told to pretend like she's SWAT and go look for bombs, right? But you see how we're articulating the material facts here? I'm sort of saying it with some passion, but the facts are what they are, right? Okay, let's keep going.
Ms. Rothwell accompanied Mr. Anniker through various classrooms to search for bombs. After she completed the search, deputies gave Ms. Rothwell permission to begin cleaning the suicide scene. She found a book bag in the corner, but did not realize that it belonged to the victim. Ms. Rothwell picked it up and began removing items from the area when one of the deputies told her that the bag needed to remain where it was. The deputies did not tell her why or warn her of the contents of the bag, so she dropped it on the floor.
All right, anybody else? Next. Yes, ma'am, thank you.
The Spokane Bomb Squad ultimately arrived on the scene and employees were asked to leave the area. Ms. Rothwell complied and went home. When she returned, she watched the bomb squad detonate a pipe from the book bag she had picked up and dropped earlier.
Let's stop right there. Can you imagine this woman's position? She is at home and she sees this bag and her thought is, oh my God, I picked that bag up. I dropped that on the floor and it had a bomb in it. All right, so the material facts. We just want the salient details that give us enough of the background so we understand the issue. Yes, ma'am.
I had a question, because it says a pipe, and so you would assume a pipe bomb, but it doesn't say pipe bomb, it says it had a pipe.
It did detonate a pipe.
Yeah.
Detonate a bomb.
A bomb piece. Let me ask you this. When you write this from Ms. Rothwell's perspective, we do those 4 points of view, right? And you're articulating this from her. I want you to keep that precision in mind when you flip it and we do it for the school, right? When you do this from Ms. Rothwell's position, I want you to ask yourself. Seriously, what do you think?
Yeah.
Right? Whether or not you call it a pipe bomb, but she knows that she was sent to search for bombs. And now she's seeing on TV there's something that's associated with the bomb in the bag. Do you care with how little or big the association is? No. Right? But I like your point, because when we write this from the other side of this perspective, from the school side, we're gonna maybe we might emphasize that. But we're jumping the gun. So material facts. So let's see here. Some of the work is done for us because we're using this case in another place. So I'm going to pull something up real quick. So when we write our material facts, do you see how we're not going to, how many pages are these facts? 1, 2, almost 3 pages, right? But your document would not be called a case brief if you spent 3 pages articulating to us the material facts, okay? So the point here is that you're going to synthesize this information. Are everybody okay with that? Yes, yes, yes? The material facts is not going to have the information about the lawsuit in there. We're not to that point yet. All right, we're just talking about what's the story in terms of what happened. How did this case even get to court? Did I lose anyone? Are we okay with that? Okay. All right, so the next part is the procedural history. The procedural history, here's what we're going to know. Okay, so who filed what? So based upon this story that happened, right? Who filed what in what court, and what did that court do? Did I lose anyone? Are we okay with that? All right, so let's see if we can find the procedural history in here. Look at page 5. And I'll leave it at that. Look at page 5 and see if you see some procedural history.
Standard of review.
Not yet.
Claim,
Too far down.
her claim against the district.
Look back up. Look back up. Yes, yes, yes. Now she's hot. All right. Procedural history. Ms. Rothwell filed suit against the district and Superintendent Green for intentional and negligent infliction of emotional distress, alleging that she suffered and continues to suffer physical and emotional distress as a proximate cause. So basically, we're going to truncate this. So the plaintiff filed suit against the district and superintendent for intentional and negligent infliction of emotional distress, period. With me?
Where do we see that?
On page 5, 13.
Oh, okay.
We okay? Everybody got it? I'm so sorry. I am doing you a disservice. If you don't have a pen out right now, and if you're not marking this thing up, so I want you to be writing through here saying, okay, PH, procedural history. All right, mark this baby up.
Can you say what you said again? Plaintiff filed suit against.
So plaintiff filed suit against the district and superintendent for intentional and negligent infliction of emotional distress, period. That's your procedural history. Your handwriting is so cute. Okay, let me focus. All right. Okay. So next, what's the next part? Uh-oh, hold from here. The trial court, wait, I'm sorry, I jumped the gun. The district moved to dismiss her claims pursuant to CR 12B6. I don't want you to worry about that because your first one, what's CR 12? That's a civil procedural question. We ain't gonna worry about that right now. All right. All we want to know is that the district filed a motion to dismiss, saying that her injury occurred in the course of employment and it was precluded by the Industrial Insurance Act. Are we okay with that? We're just describing what happened below. So she filed this action. The defendants, the superintendent of the school, they moved to dismiss. And what happened? What did the court do? That's right. The trial court granted their motion, and she's now doing what? Appealing. That's our procedural history. Now, you're going to be tempted to go further and say, this court reverses, or this court did it. That's not part of the procedural history. It's not history yet. With me? You only want the history up until the time this court issuing an opinion. You only want that history. Illustrate this. Here we go. Remember our triangle we drew last Monday? Oh, on Monday? We had community court on the bottom, followed by district court. Then we had superior court. Yes, yes, yes? I know we talked about this. Okay. All right, Court of Appeals. All right, so where did she file at?
District.
Did she file in district court? Yeah. Yeah, it was against the district. Let's presume she filed here in Superior Court. Okay? With me? Mm-hmm. So we just want all the history below up until the time, because now this court has it. Okay? So we just want everything that happened up until this court gets it. Does that make sense? Okay. Are we okay with the procedural history?
Yeah.
All right, what's the next section? I'm hot.
Issues, questions, presented.
All right. Issues, questions presented. Now, here's,
This is at the new court?
yes.
Okay.
That's right. Because remember, whenever we have an appeal, right, someone is saying, I'm appealing because the lower court did something incorrectly. They erred. They got something wrong. Okay? Now, what that something wrong being alleged, that's going to depend upon the case. All right? But at a baseline level, whenever you get an appeal, somebody is saying something below was not correct. And we want this court to take a look at it. We all right with that? Okay. Now, sometimes we're going to get a very lovely court opinion. The court is going to be so nice to us. They're going to say, the issue before us is, and they'll tell it what it is. Or they'll say, the parties argue, and they'll tell us. Or the parties contend, right? And that's a beautiful opinion, all right? And I think this is a beautiful opinion. Look and see if you can tell where the court says the issue is. There we go. What, give us a page number. Where are you at? Page 5. Under analysis, the issue. See, when you see that, when the issue is whether, you should just stop right there and just smile. All right? The issue is whether the trial court erred by dismissing Ms. Rothwell's claim against the district based upon the exclusivity provisions of the Industrial Insurance Act. And don't worry, we're going to talk a little bit more about that, okay? Are we okay with the idea what the issue is?
How far do you go through the issue? Is it like the whole?
So the court's going to explain to us more what it is, right? But all we want is a clear presentation of what is this court being asked to decide. It could be one issue, it could be two, it could be three. In this case, we got about 2 issues, okay? But you're going to be an active reader. So as you're going through, you're going to say, issue. And then you're going to keep reading. Because maybe there's another issue too. Is that okay? All right. Let's see here. What's next? Here's that. Now I'm going to tell you right now. Oh, yes.
I got the first issue, but what's the second issue?
We're going to get there. Hold on. All right. We're coming back to it. Don't worry. We're going to come back to it. Point of view. Remember we talked about that critical thinking model and I said that I want you to be able to articulate several distinct points of views, that you don't have to believe it. You don't have to make it a part of your belief system, right? But the process of critical thinking requires that you set aside your emotion and your passion and your position and you say, let me spin the same set of facts and look at it and evaluate it from a different angle, right? So that's what we're doing in the point of view section. So I want you to articulate a point of view for the plaintiff, and then I want you to turn around and with the same amount of urgency and conviction and authority, articulate a position for the defendant. And then try to articulate 2 additional perspectives. Public policy, moral, religious, economic, I don't know.
Do you want us to quote actual
This is very beautiful.
to back up their...
That's a great question. And we're going to talk about quoting in just one moment. When you get to the point of view, you should not be quoting. Because this is your analysis. This is your engagement in critical thinking process. So who right now can give me a point of view for the plaintiff? Yes, ma'am.
So when she was asked to clean up the suicide scene, and actually that's a hazmat, and this should have been done. I mean, we're saying suicide scene, or something that they mean blood and whatever else. You know, that's not part of her duties. To be cleaning up that kind of material, and if she's looking for a bomb, she would have no idea what it would look like unless she's a bomb expert. So those fall out of her range of duties.
That's right. That's right. So let's back up a little bit. Every time you read a case, you're gonna be doing double duty, all right? Because you're practicing doing the case briefing, but you're also learning about that particular law that this case is about, all right? So let me give you some more context, some more foundation. If you're injured on the job, ma'am,
We have in Washington State something called what, you know? L&I, that's right. So if you're injured on the job, it's a no-fault system. It happened on the job, you were doing what you're supposed to be doing, then you don't get to sue. You get to file an L&I claim, right? And if you're off work, you'll get what we call time loss benefits, a portion of your pay. If you can't go back to that job, then you'll get some retraining, some vocational skills. Are we okay with this? All right. Now, what she is saying is that this was intentional infliction of emotional distress. This was negligence. But she's saying this is not something that should fall under the Industrial Insurance Act. Have we lost anyone? Are we okay? And she's saying that it doesn't fall under that because I was not performing. I was not in the course of employment. That's her first issue. I was not in the course of employment. I am a custodian. I may clean toilets, but it is not in the course of my employment, the regular function of my duties, to clean brain guts and bones. If you're laughing, but this is her contention. Don't you think it's a big difference? Right? You can clean, but it's one thing to actually clean blood and brain mass. Can you imagine how disturbing this might be? And then, to top it off, she knew the student. This wasn't a stranger. She had a personal relationship with the student, right? And she was still required to clean up this blood. So that's her contention, okay? The school district is saying what? That's right. The school district is saying, hey, no. This is that you were injured on the job. This is associated with the job. It's associated with you doing the work of your job, and therefore you don't get to sue us. You have to go through your remedy of the Industrial Insurance Act.
Is it in our contract that she'd have to clean up this?
Now, why are you trying to complicate that question? Stay focused. Get back on track. All right. Yeah. Okay. All right. So we're gonna assume no contract issue. All right. Is everybody okay with that? All right. So now when we get to the point of view now we understand more about why she's saying this is not part of my job. You with me? All right. Who's gonna defend the school district here? Come on now, we all have to do it. That's the point of the critical thinking. We all jumped on her bandwagon, but she could be wrong.
What about if the blood was considered part of her job description? Because I know custodians do have to clean up.
Okay.
Yeah.
All right.
Yeah. Otherwise, they still have. Who else is going to do it though?
Okay. Yes.
Some of the parts that they were asking are going to be like the soot from the bomb detonation. That is part of her job because it's just something on the rock or whatever, maybe like a rock formation on front. It's like cleaning up, basically, is what they're trying to say. It's just cleaning.
Okay.
So to them, it means nothing.
All right. Yes, ma'am.
When it came to the bomb thing, when the principal went with her too, everybody kind of helped.
That's right. That's right. So this was not a personal thing. Everybody. This was a traumatic event for the entire school. Everyone was tasked with doing something to provide assistance, right? And everybody did that in the course of their role and their duties as staff of the school.
And
right?
it wasn't intentional to harm her.
That's right, exactly. And there was no intent here. Everybody had the same traumatic experience. Everybody okay with that? You're looking at me like, I don't buy that mess. But that's okay. You don't have to. But you gotta be able to articulate it. You gotta be able to put everything else aside and take it on. Do you think the attorney that you work for, do you think they're gonna have some clients that you don't like?
Oh yeah.
I tell you right now, I got clients right now, I just want to cry. Okay? But nonetheless, you have to look at the merits of the case. All right? Are we okay? Did I lose you? Are you feeling okay?
Yeah.
You hanging in there? All right, okay. All right, so the plaintiff, the defendant, and then two additional points of view. We get for the parents, the school itself. All right?
Is that what we're doing?
What now?
Are we going to pick our own case?
So the cases that you do your case briefing from will come from the cases that are in your text. Okay? And there'll be a specific list that you get to pick from. Okay? All right, points of view. So now, the next part of it is the rule statement. So remember how we did our thing over here on the board? We did TCC and we talked about how the court has to look for some guidance, right? Hopefully there is some guidance. If there is, maybe they'll look from previous cases, they'll look through the statutes or whatever, right? So this is our rule statement.
Here, we're basically what we're doing is summarizing what is the court going to rely upon in order to answer this question. Okay? So what's one of the rules that the court is focused on? That's right. So we're talking about the Industrial Insurance Act. So we need to define that. We're also talking about what's course of employment. So the court's probably going to look at that. And the other thing that we look and we see is the discussion of whether or not it's an injury or whether or not it's an occupational disease. All right? And so we would articulate the definition of that as well. Because we're getting back to the second part of the issue. Dylan and I want to say Ellie? All right. So the second part of the issue was, so one was the course of employment. So Ms. Rockwell says, hey, this is not a part of my job. It's not a course of employment, right? But then the other issue is, whether it's a part of this or not, is it an injury or an occupational disease? So take a moment and look at the case and see if you can find this section where the court gives us a definition of injury. So let me do it like this. This side over here, you guys look for injury. This side over here, you guys look for occupational disease. Okay. By the way, you work as a paralegal in the L&I division of the Attorney General's office. Guess what you get to do? What are we doing right here? You get to mediate these cases at the board too. Oh yeah. All right, just let me know when you're ready, when you find it. Yes, ma'am.
I think I found the
You found something?
occupational disease.
Huh?
The occupational.
Okay. You're supposed to be looking for injury. But that's all right.
I need more on this side.
All right.
Sorry, it's just
That's all right.
popped my eye for.
You have injury?
Yeah. Injury as a second tangible habit.
All right, give me a page. Give me a page.
Page 6, paragraph 25.
Page 6. Paragraph 25. An industrial injury is defined in the Act as a sudden and tangible happening of a traumatic nature, producing an immediate or prompt result and occurring from without and such physical conditions as result therefrom. We okay? Industrial injury.
Yeah.
Occupational disease?
Right below it.
Right below it. Such disease or infection as arises naturally and proximately out of employment. All right? So that's the next part of the issue. Is what happened to her, does it constitute an injury or an occupational disease? Now, what's Ms. Rothwell's contention? Is she saying this is an injury or an occupational disease? Yeah. She's saying, no, this is not an injury and it's not an occupational disease because did this happen? Because her thing is she wants to say it wasn't just one thing, right? It was a whole bunch of things. It was having to report there to clean up the brain matter, having to search for the bomb. Then later on seeing that the bag that she carried might have had a bomb in it or a piece of a bomb, right? So she said it was a whole bunch of different things. It wasn't just one thing. Is that okay with everybody? What do you think about that? Do you agree with her? So you think that's a part of her job? So you're back to the court.
It's the same thing as like a firefighter. Like if you go to a home, you find out later on that it was somebody who wrote you for 20, 30 years, and like, dude, like, it's just.
Okay. All right. I take your meaning. All right. I think that's a great point. That's something that we'll articulate for her. All right. What do I get over here, ladies? Hold on. I'm gonna come back to you.
It sounds like an injury to me.
It sounds like an injury?
Traumatic nature.
Traumatic nature? All right. So you are disagreeing with Ms. Walkwell. You don't, right?
Yeah.
You think that it is an injury and that it does fall under the Act. Is that right here? Okay. All right.
But it wasn't an immediate or prompt result.
It wasn't immediate?
No, it took time. Once she got home after it all finished, it's like
the traumatic experience.
I think that would be argued, I think that's immediate.
That's
But in paragraph 7, she's stating that Ms. Rothwell asserts that she experienced emotional distress or post-traumatic stress, PTSD, as a result.
But that didn't show up until weeks later.
All right, this is very,
But
very
it
good.
could have happened right after she saw the news.
They're gonna argue that she didn't come forward.
I think.
Okay, yes, ma'am, over here.
Wait, if she was that uncomfortable, couldn't she have said, I'm uncomfortable because I felt down?
Okay.
Like, when they asked her.
All right, yes, sir, what do you
Why
think?
is the other custodian allowed to leave?
Yeah, that's
Yeah,
what I
she
was gonna
did
say.
Like, couldn't
She went home
Good
distraught.
point.
Who's the real?
You know, yeah, I don't know. That
It
is.
says here that she went home distraught.
She was distraught.
They called her in and didn't tell her why.
But
Yeah.
then they
No,
told
you
her to go
love
home for 30 minutes. She went home for
But
30
isn't their
minutes
definition
and
of like
then
a
came back.
sudden means like you fall down, you break your leg. Or you fall down, you break your leg, That's sudden.
Yes. All right. So this is all very good conversation discussion. And this is what's going to help you do the analysis, the application part. All right. So let's come back up to the rules section first, though, okay? But this is very good. All right. So you get the idea, right? In the rules section, what you're going to do, you're not doing it. So all this conversation, this is great. But we're going to save this because in the rules section, we just want to say what the rules are. Course of employment is defined as XYZ. Injury is defined as XYZ. Occupational disease. My brain went dead for a moment. Okay, it's defined as XYZ. You with me? We okay? Did I lose anyone? Are we okay with that idea? Now, all this discussion that we're having, guess where that's going to get to come in? In the application section. Because that's what where we're going to discuss and summarize how the court applies those rules to the facts. Are we okay with that? All right, I'm going to pause right quick and I'm going to show, let's take a look at this in action. Oh, come on. It's not letting me in. Hold on. All right, here we go. Modules. Wait a minute, sorry. Gosh, I was looking in the wrong class. What class are we in? 152. We're 152, right?
Yeah.
There we go, okay. Look now, I haven't had my coffee, my evening coffee. All right, let's see here. Okay, sorry, it took me a while. Okay, here it is. Okay. Let's make this bigger. Okay, and then let's pull this down. Will someone just get like a couple lights for us in the back there? Is that big enough? Somebody, anybody? More? All right. I don't know. What do you think? You guys okay with that? Is that good? Perfect. Any more? We're gonna fall asleep because I'm tired. All right. Okay. So let's go down to the rules. The Industrial Insurance Act provides an exclusive remedy for workers who are injured during the course of their employment. Do we agree that that's one of the rules the court refers to?
Yes.
Yes. An industrial injury is defined as in the act as a sudden and tangible happening of a traumatic nature, blah, blah, blah. Do we agree? Okay. Occupational disease. Okay. Let's see. While there are no stress related, okay, I'm not sure about that one, but I'm sure there's a citation. Is in there?
Yes.
Okay, good. Okay. Application. So we're going to start this process. So in the application section, I want you to breathe, right? You got this. You can do this, all right? We're just gonna walk through the court's analysis. So what's the first thing that the court explains to us? That's right. So we're gonna say his response was course of employment, all right? So we're gonna say the court first looks at the issue of course of employment. Okay, do we see that in the opinion? This is a great opinion. It's so beautiful. You see how they give us a little like a little outline?
A little A.
Yeah, it's a little A, right? What page is it on?
5.
Page 5. This is A, course of employment. I like this court. All right. So what we do is read through the court's analysis, and then we're going to summarize. The court first looks at the issue of course of employment. What does the court say? I guess we got to turn the lights back on, huh? I don't want anybody in.
Paragraph 23.
Paragraph 23. Yes, sir. Okay. On page 6. You guys, we're gonna have some messed up eyes. We flashing lights on and off on
The last sentence, based on the facts here, we conclude that Ms. Rothwell was acting in the course of employment for purposes of RCW.
That's right. So, but now, so what we've done, so we've jumped to the idea, we know what the court says, right? That she's acting in the course of employment. But what we want to do is explain how they got there. So you're right on the, you're very hot, right? But just back up just a little bit. So go back, look at that section, and what does the court say? Why do they say she was acting in the course of employment? Because we want to explain.
Whatever's under RCW 15.
Because she was instructed to do this.
Yeah.
That's right. So the court, so we can say the court first looks at course of employment, period. The court finds that she was acting in the course of employment because, fill in the sentence, she was following orders of her employer. Does that make sense? The court, and so if we read this further, we be able to say that, like, the court says it doesn't matter whether or not what she was asked to do was a part of her regular job. It's simply the fact that she was asked in order to do it by her employer.
But had she refused?
I don't think it matters.
But had she refused, would that work?
Had she refused?
Would the court be able to say that the employer ordered her to do that?
If she yeah. And then we're looking at a whole different type of case, a wrongful termination or something, right? But what we're focused on right now is course of employment. Why does the court say it's in the course of employment? If she hadn't followed through, then we probably wouldn't have a case. She would say, please, I ain't doing this, I'm going home. Right? And then that would have been the end of it, maybe, right? Okay, are we okay with this idea? All right, so that's our application section for that one part. Then the court next has to, so we're writing this out. The court next looks to the definition of injury and occupational disease. You're right, they look at both. What does the court say about this? So we gotta read the opinion. We can't make it up, we gotta read the opinion. So what does the court say? Let's skip ahead. Where's the court talk about the injury and the occupational disease? You guys are going to say that. Thank you. So is that the right time? 8. It really?
It's been 8 o'clock for 6 hours.
I didn't say it feels like we've been here for 6 hours. Sorry. But you know what? I'm gonna be honest with you. I was asking is that the right time? I'm like, hey, it's only 8 o'clock. We're gonna have to roll this out. I'm just kidding.
Oh no.
Bear with me. You guys are doing really good. All right. So where does the court talk about industrial injury and injury? Or excuse me, occupational disease? 25? 25. Well, remember now, in one section, they're going to talk about the definition, right? Because they're going to give us the rule. And then in the next section, hopefully, they're going to talk about the application. So where are we at with that?
31?
Oh.
26.
21. I thought it was option. 21. Okay, so which one? 26. 26, all right. We agree with 26? Let's look at 26. Pursuant to WAC, that's the WAC, Washington Administrative Code. Mental conditions caused by stress that do not fall within occupational disease specifically include, so we're saying that mental conditions that are caused by stress, they do not fall within here, right? They include conflicts with a supervisor. So I'm telling you right now, if you're on the job and you don't get along with your supervisor, it does not constitute an occupational disease, right? Actual or perceived threat of loss of job doesn't qualify. You with me? Relationship with Exposure to, fear of exposure to chemicals. Does that relate here? A little bit. You can call brain, brain matter and blood chemical stuff, right? So does it qualify under here?
Yes.
What's the court saying?
Yes.
The court's saying if you're stressed out because of this, that's not an occupational disease.
No.
Yes, sir?
I think that relationships with supervisors, coworkers, and the public, because the student is a person of the public that she has a relationship with.
Right.
And that's like a stress factor.
I understand what you're saying, but what the court is saying right here is that that is not going to constitute occupational disease. Does that make sense?
Yeah. Is occupational disease in LNI?
Yeah.
So this gives credence to her argument because she's suing outside of LNI, right?
Well,
She's saying things outside of LNI, so I can
They're just
sue
determining.
for this, right?
right, so I see where you're going here. So what we're looking at right now, okay? Now, can I have everybody's attention? I want to make sure we're all on the same page, ladies. Corinne, you okay? All right. So what she is saying is, what happened to me first was not in the course of employment. You okay with that? Okay. The second thing she's saying is, it was not an injury. And it's also not an occupational disease. And the reason why she's saying that is because remember, what's the definition of both of those things require that it be something immediate, meaning something had to be on the job and then I immediately had some effect from it. Does that make sense? And she's saying that I am not limited to this Industrial Insurance Act because A, cleaning up brain matter is not part of my job. And B, what happened to me was a series of multiple things. It wasn't just one thing. Does that make sense? Is that okay? All right, good question. All right, so application. So we talked about the course of employment, and now I kind of just hinted at the application part for the next section because does the court agree with her?
No.
It's an injury.
Do they?
Yeah.
It is treated as an injury under RCW.
Do they?
Yeah.
Do they agree with her or do they disagree with her?
They disagree with her, they think it is private. Well, isn't it kind of both, because it should maybe said, yes, it was in the course of your employment because you were directed to do it, but then they agreed with her because it's not under the.
No, they did not agree with her, they agreed with the court. They agreed with the court. They agreed with the dismissal.
No, they disagreed.
Yes.
Where?
Give me some authority.
Paragraph 36 here.
He found it. Look at paragraph 36 on page 8. Similarly here, Ms. Rockwell's PTSD did not result from a single traumatic event. Rather, it resulted from a series of incidents over a period of a few days. Blah, 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 blah. Therefore, we conclude it's not an injury or an occupational disease. You with me? So the court agrees with her that it was not just one thing. If it were just one thing, right, with an immediate result, it would be under the act. Is that okay? Yes, yes, yes? All right, so in our application section, we're going to say the court examines whether or not Ms. Rockwell's claim, whether or not she had an injury or an occupational disease. The court says that because, and then we just take the language, because her injury resulted from a series of incidents over a period of blah, blah.
But do we have to address the course of employment as well in the application?
Yes, we do. We did that first. All right, let me show you an example of this real quick. Thanks to your other class, we already have an example up. Let's see if I can. I'm going to mute the screen for just one moment. And didn't we do this part this morning, Courtney?
Yeah, we finished it.
We did, okay, hold on.
I'm so surprised to see it.
That's right, because I was supposed to email it to myself. Hold on. Oh. TCC. All right, let's see here. It would have been, what time? All right, here we go. Let's make, oh, that's so tiny. Hold on. Better? Yeah. Okay. All right. Blah 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 blah. Da, 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 da. Oh, then. Oh, here we go. So again, this is our rough draft, right? But look at our application. The first thing the court does is looks at the course of employment. The court determines she was acting in the course of employment. The court disagrees with that she was not, because remember she said she wasn't acting in the course of employment, right? So we're saying the court disagrees with her. And they explain that she was acting under the direct supervision of her employers. She was complying with their employer's requests. The court explains that it does not matter what she was asked, we're going to clean this up. But basically the court explains that it didn't matter that what she was asked to do was not in her job description. It only mattered that she was specifically directed to do it by the employer. Do we agree with that? Mm-hmm. All right, so then that's the course of employment issue, which is explaining what the court's analysis was. How did they apply the rule to the facts? All right, then we say, it's not moving, hold on. All right. The court then examines the question of whether it is an injury or occupational disease under the Act. Do you agree with that? Is that what we just said? As to whether or not it's an injury, the court determined it did not result from a single traumatic event. Do we agree with that? Mm-hmm. As to whether or not it's an occupational disease, the court determined it did not fall under this because the trauma did not result immediately. Is that right? Remember they said it's over series. Life is stressful. We're going to clean that up. You won't see that. We were just talking. All right. Okay, so are we okay with this idea? So in the application section, you're just summarizing how does the court apply the law to the facts and just walk us through the court's analysis. The more that you can talk about the case and have that sort of back and forth that we did earlier, that's going to help you understand the issues and understand the court's analysis. All right, ready to go on to the next section? Yeah. All right, what's the next section? Conclusion. The conclusion. Well, the only thing you're doing, do not complicate this. The only thing you're going to do under the conclusion section is you're just going to go right back up to the issue and tell us how the court answered it. With me? The conclusion, because remember we started off with an issue. We said, what's the issue? What is the question before this court? And then we went through and we spoke about what the rules are, what the court's going to use to address the issue. Then we did the application. And now we're saying, as a result of that application, how does the court ultimately answer that question? You okay with that? Let me show you how simple this can be. Let's go back up to what we articulated as an issue in this part. Are the plaintiff's actions for negligent or intentional infliction of emotional distress barred by the Industrial Insurance Act, which provides exclusive remedy for injuries, blah, blah, blah. Remember where we took that issue from? Remember, the court gave it to us, right? Literally, we could copy that, go right down the conclusion, and say no, and answer. That make sense?
Is it supposed to be in a yes or no form?
And you need to have it be in the form of a question. I think that will help you, right? You okay with that?
What do you want for a question?
So when you articulate the issue before the court, that issue or question presented, you're always going to have in the phrase of a question. Did the trial court err?
So your conclusion is an answer to the issue.
That's right. You're just telling us how did the court answer the issue.
I'm confused though because it says that they didn't err at the very end.
What now?
It did not err.
What says it didn't err?
The trial court properly granted 9 months.
Oh, I know why you're confused. Are you at the very end of the opinion?
Yeah.
I want you to go back. I know what your confusion is. Go back. So remember when we talked about terms last week, and I told you how we talked about the court's opinion and how you're going to have the majority opinion, and then sometimes you can have those people who are like, we don't agree.
Oh.
You're reading the dissenting opinion.
Okay.
So that's why they're saying the trial court didn't err. You okay? So you got to make sure you're in the right place. Because that connection, I see now. I understand your confusion. So go back. So
this one says concur.
Right. So you have in this opinion, you have the majority opinion, and then you have a concurring opinion that starts on page 8, and then lastly, So if you go and you look on page 8, it says I concur.
Right.
And so remember, what's the basis of a concurring opinion? They say, okay, well, I agree with what the majority court did, but maybe I just got there for different reasons. But I agree ultimately with what they did. Is that okay with everybody?
Okay.
Yes?
Yes.
Okay.
I thought this was part of this, so this judge
I did
said
too.
the,
Yes.
the dissent.
And then when you look
So
on
it ends right
page
here. Yeah.
8, then there's a dissenting opinion that starts.
So we don't wanna look anywhere really below.
No, because that's gonna mess you
Okay.
up, girl.
Damn it, 'cause my other
I
has
heard
to start with this.
this.
Here's the
Now
thing.
this is dissenting.
Oh.
Okay.
Remember how, hold on, let me get everybody's attention, all right? So last week, we spoke about the construction of the opinion, and we had this conversation about how sometimes that dissenting opinion, it can have information in there that's good, right? And that will ultimately, the court might rely upon in the future. It might look back and when it's sort of going to change direction, right? And it might actually rely upon some of the stuff that was in the dissenting opinion. But you never know the import or weight of that until, you know what, future happens, right? So for purposes of this assignment, you don't want to focus on the dissent. You want what was the opinion of the court, because that's what counts. What did the court actually, what was the authored opinion at the very beginning? All right? The concurrent opinion, that can be helpful. You with me? But for the most part, you're going to focus on the majority opinion. Yes, sir.
How many judges decided on this?
How many judges decided on
I'm trying
this?
to figure that out.
I don't know off the top of my head. Sometimes you can tell by the count here. The Court of Appeals, 1, 2, I don't know. But John, I wish I could tell you that was important.
Well, the reason I ask is, I'm like, if it was if you have a situation with 3 judges to decide on it, and you got 1 dissenting and 2 who agree but for different reasons.
Yes.
What is considered the
Yes.
concurring opinion? What's considered the majority opinion?
Civil Procedure 2.
Civil
Procedure 2. All right. So are we okay with that? Though I don't want to complicate this any further. We all right? Okay. Yes, sir. I'm sorry. Oh. Oh, okay. Okay. All right. I didn't want to leave you out in case you had a question. All right. So we okay with this? All right. So the next part. So let's see here. So we talk about the conclusion, the holding, judgment. Judgment. What's the judgment?
What does she get?
What does the court do? Are they going to reverse?
Yes.
Yeah.
Are they going to affirm? Are they going to remand with instructions? So what did the court do in this case? They reverse. The court reverses determination of the trial court. Okay? Are we all right with that? I see some confused faces. Where does it say? Yeah.
If they reverse, do they also?
All right, so hold on one second because I got a lot of conversation going on and I really appreciate that you're involved, but I want to make sure that we're all getting this content, okay? All right, so did we answer your question, ma'am, in terms of where do we find out that all right, so remember, always go back to your authority. So, right, go back to the record. We're not making this up. All right, so whatever we're looking for in terms of that information, we should find it somewhere in the opinion. It's going to tell us we affirm, we reverse, we remand with further instruction. If they don't tell us, that's an awful opinion. And I'm awful for giving it to you. All right? Okay, now your question.
If they reverse, do they then give her a judgment or
Now she has the right to go to court.
damages?
That's right.
Do they award damages to her at this point?
So what happens now? So the court reverses, then she gets to go back to where? To the trial court.
Yeah.
And now her case is basically reinstated. Now maybe we might decide, shoot, we already lost an appeal school. Let's just go ahead and settle this case, right? Or maybe you decide, well, shoot, let's just go to trial again then and see what happens. You with me?
Huh.
We're going to come back to this case because this is not the end.
No.
Yes, sir.
When she goes back to court, is it, what is the term, like nouveau or something?
Oh, in terms of review, the standard of review?
Yeah, so when she goes back for this new trial, do they look at it as like it wasn't contested and everything?
Okay, very interesting. Okay, so I'm glad you asked the question. Don't be confused about the standards, okay? So that de novo thing, remember that comes into play in terms of looking at how this reviewing court is going to examine the issue below in terms of what level of deference they give to the court below, all right? So let me just make this more clear. So when we talked about our appeal thing, the different levels here, right? Superior Court, we're appealing up to the Court of Appeals. That de novo standard, that says, okay, when the Court of Appeals gets this issue, right? When they get this issue, what level of deference are they going to give to the decision that the court made below? Are they going to say, you know, we should probably defer a little bit and look with an eye towards supporting whatever the trial court did? Are they going to do that? Or are they going to say, no, our standard is de novo. We should look at this with fresh eyes and not give any deference. So that's what that means. Is that okay? All right, so when she gets to go back down, so we get our opinion, right? She's happy, her lawyer goes, guess what? We won our appeal. Yay! All right, so now what do? Well, we can talk to the school district and see if they want to settle, or if they don't want to settle, we go ahead and we proceed to trial. With me? And we start all over again. And then what we're looking at is not a standard of review, but we're looking at the plaintiff and her meeting her burden of proof, which is going to be what? But what's the standard? What's the burden of proof standard she has to meet? Preponderance of the evidence.
Would she then she would get a new judge at that point?
Maybe, maybe not. Yeah, she could get the same judge. You want to pick the judge? You can't pick your own judge.
No, not necessarily pick the judge, but he's going to have
You're
some
uncomfortable.
sort of-
You're uncomfortable with the idea of her going back to the judge that ruled against her?
Yes.
Ah, yeah, but she very well could go back to that judge. Yeah.
So how much weight does the appeals court sending it back down how much weight does that put on that judge?
I think it depends. Well, here's the thing. If it's an issue of rule of law, then I think that most judges, they're going to be respectful and they're going to honor that, right? But you do have some judges that, they can be interesting in terms of how they respond, because it's a correction. Basically, the higher court has said, hey, you did something wrong. This was not you should not have dismissed this case.
So could it keep going? How many times can it be appealed? Like if she did, really, like if the judge still saw it the same way or something, or the same, or is there's the trial.
So it can only go here. It can only go as far as depending upon what the issue is, right? Because we're state law, right? So are we going to ever get to federal court? No, because it's a state law issue, right? All right. So she can only go as far as our Washington State Supreme Court. So let's say she had lost here at the Court of Appeals, then she could have appealed to the exactly, and then it's done. If they say the court was right, then her case is over.
But if the appeal was won and it goes back down to Supreme,
Then it goes back, exactly.
but if the same judge says no, it's still not okay, she
No,
take it back up.
no. That is going to be a rare occasion. Because basically what you're saying is the court saying, yeah, whatever, Court of Appeals, I don't think so. No, your case is still dismissed. And no. All right, typically there's respect of the hierarchy.
If they go back down to the trial court, can they present new?
Yes, because she never got her trial. Remember? She never got her trial. This was so here's the thing. I don't want to go beyond the scope of this class because a lot of this is civil procedure. Okay? And right now, we're not talking about civil procedure. We want to talk about the substantive law. But in your case briefings, I do want you to have a baseline understanding of procedural history and what that means. So you're asking very good questions. In fact, if this is civil procedure, I'd be on a hot roll. This would be really great. But I don't want to confuse the issues. All right? So these are great questions. Okay? But for right now, what I want you to just appreciate is just the general outline of the procedural history. She filed her case in this court. A motion to dismiss was granted. She appealed. We okay with that? That's the extent of what you need to know and understand. And then for the judgment, I need you to be able to find in the opinion, did the court reverse, did the court affirm, or did they remand with further instructions? Okay? Is that all right? I'm going to tell you right now, these are scintillating questions right now. When you start to do this, you're like, oh, forget all that. I'm just sitting here, what she say she won't, I'm doing just that. All right? Okay, so let's keep pushing.
What do we got now?
So now we talked about the judgment. The last part of the case briefing is the significance. Basically, what do you take away from this case? What are the implications? What do you now understand about the legal issue? Right? Is there anything you can think of right now?
Is this going to be another opinion? Our
This is
opinion?
this is probably the only place where you get to just go by your
What we want.
Yeah. What do you think? What do you take away?
Several point of view,
Okay, a little bit. So the point, but I'm glad you said that. I don't want you to think the point of view is about being about you though. You with me? I want you to think about the point of view as being about different perspectives, the plaintiffs, the defendants, the social point of view, They could line up with yours, right? But I want you to be able to jump right here, plaintiff's point of view, jump right here, defendant's point of view, jump right here, public policy point of view. You with me? All right, in terms of the significance, one of the things I took away, I was like, really? The court says this is the scope of the course of employment? I wouldn't have thought that. I would not have thought that a janitor's duties, right, could be thought to encompass cleaning up rain matter from a suicide. So that for me was very significant. Now I appreciate the court's, sort of articulation and explanation of what constitutes course of employment. That it doesn't matter that it's something that was outside of her duties in that sense. Is everybody okay with that? Now you might take away something wholly different. That's your case briefing. I want to tell you.
Are you going to give us a different case now?
It's going to take practice, but so you can have this case. I'm going to post this example on there, and you're going to be able to come back and reference this, and you'll also be able to come back and reference the lecture too. And we'll do these a few of these, all right? Let me really quickly, yes ma'am?
How many of the case briefings were you going to say 2?
I think there are 3. Look at your syllabus. I think there are 3. Are there 3? Yes, it was 3. Because remember, I think it was a typo.
Then 5 and then.
That's right.
Yeah.
That was a mistake. I don't want to read that. It was like there are 30 of y'all. I'm not reading 5. No, just kidding. So there are 3. How you feel? All right. It's okay. It's going to take some practice. Go back and look at this again and see if you can do this on your own. Because you'll have a cheat sheet. You'll have this, right? So go back, read the case, and see if you can do this by yourself. And then just cross-reference with our draft here. I'll have this posted to our Canvas site. I can't talk over you. I'm tired. I'm on the Atkins. I'm hungry. I'm hot. All right. So I'm going to have this posted to our Canvas course site by tomorrow. Okay? And I missed a question over here.
I was assuming that our homework this week is going to be doing case briefing.
No, your first case briefing is not due until I think past our next week's class. But I want to introduce it because it's a lot, and so we're going to come back to it on Monday too.
Okay.
Okay? Yeah. And then you're going to start to so for example, next week when we start to talk about torts or whatever, you're going to be reading cases, and so all of this is going to help you be able to understand and analyze those cases. Okay.
Sounds good.
All right. Okay, I'm inclined to let you go. You guys did a great job.
What does the ATC do?
Oh, thank you so much. So you'll notice that you have a couple different ATCs. You have only 4 of those that are actually required, right? So there are a total of 7. The idea is that you're introduced to the material, and then you have some practical application exercises. All right. You get to pick which one of those exercises you do. There's 7, but you only are required to do 4. Let me show you an example of what I mean, and we're going to come back and talk about these on Monday. But your first.
What is an ATC?
Hold on. Oh, all right. Somebody's been listening to me. All right, hold on.
Yeah, not the first one.
Yes. Uh-oh, I'm in the wrong class again. Hold on a second. All right, here we go. So thank you. All right, so let's take a look at this. Oh, that's too big. So You'll notice there's not a due date for these because I want you to do them after we've covered the material and you feel comfortable doing it, all right? And like I said, you'll find some of these, you feel like, it'll help me, or I already got this, or I already understand it. So that's why you get to pick which ones you do, okay? So for example, last week and today we talked about the jurisdiction of the court system, sources of law, and things like that. So look at these questions. Find a website for one of each type of these courts, municipal, district, and superior, and provide the following information: the name, address, and telephone number. Describe the jurisdiction. Is it limited or is it general? How many judges are there? You see, so now you've been introduced to the concept. Now I want you to actually have some practical application. All right? Can I actually find these courts? Oh, okay. There's Tacoma Municipal or Tacoma. There's Pierce County District Court. That's one of the courts we spoke about. It's a court of limited jurisdiction. There are how many judges on there? All right, let's look at the next one. Give the link for the website where we can find a directory of each court in Washington State. So where can I go to find a directory and a list of every single court in Washington State? So you say no, but here's the thing though. You're gonna look at the exercise. You might say, okay, I'm at a place where I already know this. Remember, because we talked last time, some of you guys are at the beginning, some of you at the middle, some of you at the end. So some of you might look and say, okay, this is not an exercise I feel like I need to do. I guarantee you though, as we move through, the other ones you'll probably want to do because you haven't had that content just yet. But that's why I let you pick 4 of the 7 that you'll do. Is that okay? Is that clear?
If we do all of them, do we get extra credit?
I hadn't thought about that, but I'll think about that. Okay, let me think about that, okay? I like that question. All right, let's see. But let me show you some of the other questions and I'll let you go. Because I want you to understand that it's really just sort of bringing it together. How many circuits are there?
4.
So there are a total of 7 of these. You're only required to do 4. How many questions and how they are, or how many questions there are, is going to vary by the assignment, okay?
But are they all up?
They're not all up. Do you want them all at once? I don't want to give them to you all at once. Because then you're going to ask me, no, because as you get the material, then I will open them up. But I open up now, you're going to be asking me, well, what's this and this? I'm like, we ain't got to that in class yet.
But will they be open?
Probably shouldn't, because I would be the one.
Yes. Yeah.
We're not at the last video.
Exactly.
Okay.
Are we okay with it? So my preference is, as we approach the week, you're going to have it open up. Like, so this has been open since last week. So I will open it up so when we start to talk about this material, you have it and you can go in and do it, okay? But some of you may decide, hey, I've had some procedure, I've had interview investigations, I already know this stuff, I don't need to do this one. But the next one, when we talk about torts next one, wait a minute, I don't know what this is. Let me actually do this exercise because it'll help me understand this content. Is that all right?
Yes.
You sure? Yes.
Is there like a discussion question you want us to attach on the
What now?
Upload a file.
So you're going to upload a file, yes, to answer these questions, exactly. And they're pretty straightforward. Locate the internet address for the Washington State Legislature and identify one bill introduced. You know what I'm saying? So just to give you some practical experience, because here's the thing. If you're going to be a paralegal, right, you ought to know where the directory is for all the courts. I'm just going to say it right now. If you don't know, you're not coming to my office, right? You should know how many courts we have here. You ought to know where to get to the state legislature website at. Okay, so they're not complicated questions at all, but they're just an opportunity for you to bridge some of the abstract content we talk about on the board here with some practical stuff. Okay? You all right?
Yeah.
Feel good?
Hungry.
Hungry? I hear you. What are we gonna eat? We need to bring some food. I'm saying right now, if I give extra credit, y'all bring some food. I'm just kidding. All right, y'all have a good night. Thank you.